Hello, everyone. We are here to hear the cases, the state of Andreas versus Richard Anderson. Case 12-17675A. Before we get into the things, we are continuing conversations from pre-trial motions. You can all be seated, by the way. We are continuing discussions that were taking place in pre-trial motions. Prosecutor Cartwright, you are charging the defendant Richard Anderson with
conspiracy to commit first-degree murder.
right, and then first degree felony murder of an LEO. However,
Correct.
from the Supreme Court ruling from Justice Granny Noonan, conspiracy will be removed, and this case is now only for first-degree murder of an LEO. The defense, Oliver Hall and Cyrus Hunts, are for defendant Richard Anderson. And where is your client there, Hall and Hunt?
Your Honor, he's having some issues getting on the train, to my understanding.
Okay. So, in pretrial motions, we were taking a look at the case and found some inconsistencies with what was submitted from the previous prosecutor on this case, Senior Blackstone. From my understanding, this case was to hear the murder of Julia Pierce. However, what I'm being told, that is not what was supposed to be. Prosecutor Cartwright, could you please elaborate for the court?
So this case was to hear the conspiracy to commit murder of Kavor Arnom and then Marshal Aaron Sorella. And that was on September 21st at the funeral of Julia Pierce.
Okay, and so this is not to, you are not charging Richard Anderson with the murder of Julia Pierce. This is for the conspiracy to commit first-degree felony murder of Kavor Arnom and Aaron Sorella.
Correct.
Okay. And from what I've also heard, the state previously within, and Prosecutor Blackstone was here in this case, he was trying to charge the defendant with all sorts of other ancillary charges. However, from what we've discussed, all of those charges now fall out of the statute of limitations given when this incident occurred and when we were actually hearing this case, which only leaves first-degree murder of an LEO, which has no statute of limitation here in the state of St. States. However, that is not what the state wishes to push at this time for Richard Anderson, correct?
Well, right. I believe that there was also, as I'm looking at this docket, the argument was originally made for a motion to dismiss from the 26th of August, and the indictment was filed on the 1st of October. The secondary conspiracy to commit murder against Aaron Sorella was on September 21st, which means it would have still been in the statute. And they weren't able to arrest the person for the first one until that second one occurred and he was arrested then. So I guess my question is, if there's a 28-day statute for a conspiracy to commit murder, but you are unable to apprehend the defendant within those 28 days due to no fault of your own, does the statute still just run? Do we just allow them to go into hiding for those 28 days?
Defense?
Yes, Your Honor, that is how the statute of limitations work. I mean, overall, it's a set amount of days. There are no necessarily exceptions to it. Just because a defendant or suspect could not be apprehended to either fault of the defendant or fault of law enforcement, that doesn't void the statute of limitations. It's their very specific reason.
I'd also note, too, Your Honor, a defendant doesn't have to be placed in custody for an indictment to be filed. The state can still file an indictment, and then the the court can ensure that the defendant appears at the trial, and there's nowhere saying that they can't file the charges without him being in custody.
I believe they attempted to put out warrants, and during that time.
Now, let's back up, Prosecutor Cartwright. You had mentioned that through no fault of their own, of the officers trying to apprehend the suspect. Could you elaborate that for me?
They were putting out warrants, of which I believe were declined by another judge, though they had plenty of information to be able to issue the warrant. I would have to go and research what dates actual warrants were submitted, as that was obviously not something that was included in the questioning of this case.
Okay.
Your Honor, if I may briefly.
Briefly.
The reason why the indictment was filed is because they didn't have enough evidence to prove that it was him until a later incident had arisen at the funeral. So during the time when the incident occurred until the funeral, they, to my understanding, they weren't putting out any warrants.
And if that's the case, then we got further information connecting him to a prior crime, which then would allow the statute to begin running at that time.
Sure, but that case was dismissed.
I don't believe that case is this case. This case includes the incident on the 21st.
I think.
Well,
I think
to be fair, that case was dismissed. It was appealed to the Superior Court, and the Superior Court has remanded it back to me. But technically, that case still lives.
So right. So August 26th was the date that the defense was going off of to ask you to dismiss it within the 28-day statute. But that date is the incorrect one to go off of, because the September 21st one was when we got further information connecting him to the prior crime. So the statute begins running off of September 21st, and we filed on October 1st, which means we are within the statute.
Your Honor, it's not.
with all due respect, I don't think there's really an argument here. The appeals court stated the conspiracy charge will be removed and he will be tried for first-degree murder.
Correct. I do agree with that. The Superior Court did remove the conspiracy to commit state felony, and now we are left with first-degree murder and LEO. Now, the states also have the rights to add any charges that they wish to add on for the defendant. However, conspiracy cannot be one of them because it's already been removed from the case.
Right. So we would add on 2 times attempted murder.
Your Honor, I'd submit to this court that, the prosecutors have a right to change and amend charges at any point previous to the trial. However, we've already begun. We've already gone through the pretrial motions and.
In pretrial, I brought this up and said that I would have liked to have attempted murder added.
Your Honor, they never officially.
She did do that. She did ask for it.
And that's fine, Your Honor, but this is the day of the trial.
According to Justice Sia Noonan, we are still technically in pretrial. The case fully has not begun yet.
Your Honor, respectfully, I don't understand how this court could allow the state adding a charge literally 10 minutes before the trial.
It requires the same level of information we already have. There's no further information needed to be able to add that charge. And
to be fair, you both have had significant enough time to look at the evidence that the prosecutor is going to be using. She's adding no other evidence to this case, and the only difference is that she's not charging first-degree felony murder. She's charging attempted murder of this case and using all the exact same evidence.
Sorry, Your Honor, could you repeat what you said? I wasn't hear you for a minute there.
The prosecution is using all the exact same evidence for the original case that has been available to you both for the past 3 months, I believe. She is not using any other evidence. She is simply using and applying that evidence instead of using it. She's using it to apply to 2 accounts of attempted murder and not 1 count of a murder of an LEO.
Your Honor, again, we would submit to the court that specifically in the appellate ruling, it states that, and I can quote if you'd like, what we are left with is the charge of murder. The appeals court specifically excluded the conspiracy
From the
charge, and
original
it's-
case. See,
Yes, and we would submit that only this case should be heard with charge of murder. That the appeals court only intended for the specific charge of murder, and no other charges to be heard. Again, I can read out the quote for you if you'd like, Your Honor.
Well, here's the thing. We're still in pretrial, and the state can add charges whenever they feel, so long as that it's before actual court has started.
Well, yes, Your Honor, but
Your Honor,
we're stating
also,
that
if I may, to go back on our original motion to dismiss, if the appeals court overturned your ruling based on the fact that the district attorney misrepresented the facts to the appeals court, I don't understand why we wouldn't just go back on the original ruling.
Because here's the thing, Justice Granny Noonan's decision still stands. Whether she was fed information that may or may not have been false at the time, her decision still stands. It cannot be reversed. So that is what we are working with now. So, in this case, we will be adding 2 counts of attempted murder of an LEO at this time, and we will be removing 1 count of murder of an LEO. Is that correct, Prosecutor Cartwright?
Correct.
Okay. That being said, Olin? All right, let me have 1 minute to look over the court docket real quick, and we will discuss further with this. From what I have been told, since the case, or since the prosecution is adding 2 more charges onto there, since this is a special case, defense could motion for a one-time continuance to prepare their case for, instead of a murder case, an attempted murder case. However, I am looking over the docket currently to make sure that we are still able to do that, and I will get back to you. Give me 1 moment to quickly look over the case. Okay, so after looking over the case, I will grant one extended continuance for the defense, should they wish, if if the prosecution is changing their charges from murder of an LEO to attempted murder count, or 2 counts of attempted murder of an LEO. Does defense wish to accept that continuance, or do you wish to have a moment to discuss it?
I would just have one moment, Your Honor.
I'm sorry, what was that?
Oh, I said please just have one moment, Your Honor.
Keep in mind, defense counsel, none of the evidence is being changed at that time. The only thing that is changing is how prosecution is going to use that evidence to argue their second court. If you need a recess, counselors, let me know to figure this out.
Oh, yeah, we could just have like 5 minutes. It should be fine.
See, 5-minute recess granted.
All rise. District Court back in session. Judge Morales still presiding.
Yeah, that's quick.
All right, defense counselors, have you come to a decision?
Yes, Your Honor, we are prepared to proceed, and we do have a motion we'd like to submit.
Okay.
Your Honor, we specifically have a motion to dismiss on the grounds that the indictment is being filed for the attempted murder charges, and one of the victims, Mr. Arnom, Detective Arnom, is not present. It's my understanding that he won't be able to be called today. And 2, the other count of attempted murder is for another victim that is not on the prosecution's witness list. We'd contest that this is a violation of the defendant's Sixth Amendment rights to, of course, address the accuser and to cross-examine the witnesses.
He is listed on the court docket today, that witness, Sorella.
It's my understanding that he was never actually called by the prosecutor.
Somehow the court reporter did have him on
He
there.
is currently accepted as a witness in this case, counselors.
Yes, Your Honor, but he was never called as a witness by the state.
He's accepted as a
If
witness.
he is accepted as a witness by me, he is being called as a witness to appear in court.
I believe Arnom is also on his way. So to go with their motion, then the state moves for a default judgment due to the fact that the defendant is not present.
Your Honor, we do
Your Honor,
would
as-
like our motion to be addressed.
Actually, to be fair, where is the defendant, actually, counselors?
As I said, he was having troubles getting on the train.
But you told me earlier that he was actually in city and we was waiting to see if this case was actually going through or not. Did you not say that?
No, when you asked me earlier, where's the defendant? I said that we're waiting, or he's having trouble getting on the train.
I do believe you said
From
what he
what
said.
I remember, you did not say that. You said that he is in city. Actually, Prosecutor Cartwright re-asked that question after we said it, and she says he is in city and he is available for this court case, and both of you said yes.
I apologize
I
there was some
don't
confusion, but
remember saying
he's
that.
not in the city, and I don't recall that conversation.
Motion for default judgment is again being presented then.
And Your Honor, just to respond, as this court is aware, default judgment for defendants not showing up no longer happens, and that was a precedent that the Chief Justice said a long time ago.
And yet you were arguing for Speedy Trial Act, and it would be
Shocking,
violating
so-
his own rights.
Prosecutor, hold. I'm going to be putting this court into recess for a minute or two as I speak with Justice Tiadunan.
I also have to state one of my witnesses, Officer Sorella, does have to attend other work in about 20 minutes, as he was expecting this to go 22 hours ago. So I'm not sure how we want to handle that. But he is present now.
So Sorella is here and Arnom is not.
Arnom is on his way, and Sorella is here. Yeah. So essentially, I would have had the one with the later in trial and present 2 hours ago, but now he needs to leave in 20 minutes, unless we want to take his statement prior to him having to leave.
Okay. As it still stands, this court is in recess for a moment or two. Be seated.
My interest kind of faded away.
So, Prosecutor Cartwright, where are we at with those witnesses?
Sorella is here, and I can call to get the exact location of Kavor if that is needed.
I think you just fell over.
Okay.
What?
No, that
Sorry.
that will not be necessary.
Okay.
After deliberating with Justice Noonan, I'm going to deny the defense's motion for dismissal, as well as I am going to approve of the prosecutor's motion for default judgment. From what I believe, and further I understand from the law, in a court like this, the only person that is required to appear by law is Richard Anderson, the defendant. And since the defense, and the entire time this case has been going on, never subpoenaed any of the witnesses to appear, they have been accepted by me to appear as a witness, but they are not required by the court to appear in court, if that makes sense. So, especially since the defendant has not arisen here, his Sixth Amendment right does not apply because he was required by law to be here. And since he is not here, he can't even face his accusers anyway because he's simply not here. So, in the case of the state of San Andreas versus Richard Anderson, I will find him guilty of 2 counts of attempted murder of an Elio. From which I believe, for what reason?
Well, I can say it here. This has been touched on by the Chief Justice a couple of months back. He stated that the courts no longer will issue default judgment if the defendant doesn't appear. They will issue a capias warrant, and then the trial will be rescheduled.
Okay, but there has been numerous case precedents says that judges can actually put forth default judgments, and they don't have to use a capias warrant. That is a tool that judges are allowed to use, but no, that's not, simply they're not allowed to do that.
Could we ask that we at least have a continuance? I mean, this case was scheduled within a couple of days. Perhaps if we can go back to the earlier point.
You said that you are ready to go, defense counsel, and you denied it. So no, a continuance after you had said that you were not ready, or said that you are ready for this care case, will not happen.
Okay.
So,
understood.
Richard Anderson will receive 90 months in the Bolingbroke Penitentiary and a $20,000 fine in accordance to 2 counts of attempted murder of an Elio. This court case is now adjourned.
Thank you, Your Honor.
Your Honor?
All right, everyone, please go ahead and file out of the courthouse. Y'all can have conversations outside, but we're not going to have anything in here.